introduce you before I bring you on. So don't worry, just stay tuned, okay? Hello, everyone. Can you guys see me and hear me? If you guys can see me and hear me, okay, please type in USA, or you can use an emoji of the US flag. Type in USA, USA, and then let's make sure that every one of you can hear me and see me. We have a special guest today. We have a lot to talk about, so please stay tuned and just stay engaged with us. You're welcome to our first edition of Immigration Court Series with former Immigration Judge George Pappas. We're going to be bringing him on shortly. But if you guys can see me and hear me, please type in USA. We're live on TikTok. Oh, let me just invite Judge Pappas here. Let's see if I can find him. Okay, no. I need to figure this out on TikTok, but I'm going to bring him live now, and then we can get the conversation started. You are so welcome to
Thank you.
Our first edition of the Immigration Court Series. Good afternoon to you, Judge Pappas.
Good afternoon, AK Poku. Good afternoon. Thank you.
Thank you so much for being here. Guys, you're all welcome. If you guys can see us and hear us, please type in USA, or you can use an emoji of the US flag as a signal that you can see us and hear us both well. I'm trying to invite you on TikTok, but I can't seem to find it. Okay, well, we can't hold everybody up, so maybe we should get started until I figure that out. Okay. Can you guys see me? I'm not seeing any comments. Can you guys see us and hear us well? Please type in USA. We're about to get started. Immigration Court Series, what every immigrant must know before they go into immigration court. As you guys know, my name is AK Poku. I'm a U.S. immigration attorney. And this is a series that we're going to be running throughout the year because immigration court continues to be one of the most intimidating parts of the U.S. immigration system. Once you get that notice to appear and you have to go to immigration court, it's like your whole world can come crashing down. Very scary, very stressful, very expensive, very nerve-wracking place to be. So today we're going to be demystify. We're going to be starting our series to demystify this. And for many immigrants and families, immigration court is their first encounter with the legal system or the court system. So, you can, while you're in immigration court, you can even end up being detained. You can be separated from your family, from your community, and your loved ones. So we have Judge George Pappas joining us again. Last year, we actually had a live session with him. And if you haven't watched it yet, I encourage you to go back and watch. It was what immigrants must know before immigration court. You'll find it across our social media platforms. We talked about common mistakes immigrants make. You guys have to watch it. Make sure you're sharing this across. This is unprecedented. You don't have immigration judges coming on live video to demystify immigration law. So make sure that you're liking the video and sharing to get the engagement up. So Judge Pappas is a former immigration judge, and he's currently an immigration attorney. He has seen immigration court from the bench, and he understands how cases are evaluated. In fact, he's the one that was making these decisions for many immigrants. And as you guys know, immigration judges make some of the most consequential decisions because they decide who gets deported, who's allowed to remain, who gets a green card. And these decisions are really weighty. They shape the future and lives of many immigrants. So yeah, we have him join us today. Judge Pappas, you're welcome again.
Thank you. It's great to be back, and I look forward to today's discussion. It should be very useful.
Wonderful. Thank you so much. So I know you are in North Carolina.
Yes, I'm in Asheville, North Carolina. I have one office here, and I'm also up in the Boston area. So I go back and forth.
Oh, in the Boston area as well. Okay, well, I'm connecting from Virginia. We were discussing earlier, we are snowed in. We had snow last weekend and everybody's in, but I understand your snow is coming this weekend. So all the best with that.
Thank you. It's coming tomorrow. We're ready
Okay.
for it.
Okay, great. All right. Well, let's get started. And guys, drop your questions as we progress in this video, and we'll do our best to answer the questions as they, once we're done with the discussion. Today, we want to focus on immigration detention. How do immigrants get detained? Because you could get detained. You could, there's the other type of detention for people who commit certain crimes and who are not immigrants. And there's another type of detention for immigrants. Judge Pappas, tell us some more about immigration detention. How can an immigrant get detained? What's that all about? Who's at risk? What's happening?
It's a very good point. And who's at risk also depends on where in the United States you're located. That also affects who gets detained. One common way to become detained is if you are arrested for a charge or a crime, depending upon your state. I won't go into the details, but many folks are in state jail on state charges, and Immigration Customs Enforcement learns that they are undocumented, either through the cooperation of the local police, because there are what we call 287G programs where the local sheriff or local law enforcement signs these memorandums of understanding with the Department of Homeland Security, and they are trained to screen people who are in their jail system to see if they have legal status. And if they don't, they contact Immigration Customs Enforcement, and then ICE, Immigration Customs Enforcement, makes a decision whether to put a hold on the individual. If they do, that hold usually lasts for 48 hours after the state charges are disposed of. And if within those 48 hours, ICE comes into the jail, they then detain and arrest the individual and then transfer them to ICE custody and ship them to wherever ICE has detention centers. So that's one common way people are detained by ICE. Other ways, as you can see from the TV, ICE has.
I'm so sorry. Let me interrupt you. I think you can start watching the video on TikTok, and then I can invite you on TikTok as well. That's how I can invite you. Is that possible now?
You can invite me. Let me see.
Yeah. Once you are watching, then I can invite you. I was trying to add you, but it looks like I cannot add you if you are not watching.
I don't see it. Let me see. I'm on your site. I'm on your TikTok site.
Do you see us on live? Do you see me?
Oh, I see. Oh, hold on.
Okay, yes. So just turn that on, and then I can invite you. So that okay, there you go. Let me see here. Okay, there you go.
There you go. I'm going to shut the volume down on that. Okay. All right. We're sorting out the technology here. So getting picked up from a jail is one way that ICE can detain you. Certainly, if you're in a public space.
I've invited you. You have to accept it. I invited you on TikTok, please.
There we go.
There. Excellent.
There we go. ICE can pick you up in public spaces. They don't need a warrant to pick you up in public spaces. So if you're on the street and they have an administrative warrant, not a judicial warrant, they can pick you up, or they can question you. They can stop you. Unfortunately, today, ICE can stop you based upon your skin color and your accent. Thank you, Supreme Court Justice Kavanaugh. That's a horrific thing to say, but that is now in play. It goes against all of the civil rights protections that I grew up with. No one ever was able to stop me or anyone based on their skin color or accent, but this is now effective. So that's another way they can stop you. So they can stop you in public places. They can pick you up from the jail. And they have been picking people up from courthouses starting this past year, even in my courthouse. So you're going to court, you're playing by the rules, you got a court hearing. And for example, at 26 Federal Plaza in New York, they've been picking up folks there for the last couple of months. You've seen it on TV. So there are many places where ICE can pick you up. What they do try to do is to pick you up at your home. Now, this is very, very dangerous. People have to realize you have constitutional rights when you are in your home. The only way ICE can arrest you or try to arrest you at home is if they have a judicially signed warrant, search warrant, not a warrant signed by an administrative officer of ICE. They need to slip that warrant under the door, So you can see it. And several things have to be there. One, it has to be signed by a judge. Two, it's got to have your name or someone in the household's name that has to be on there. And they have to have the correct address. If they don't have those three things, it's not a valid search warrant. They have no permission to come in. Be careful. If you open the door and let them in, you gave up all your rights. Be very careful. Don't open the door. If they come in without a warrant, they're violating your Fourth Amendment right, search and seizure. And what do you do if they come into your house without a warrant? You tell them, I do not consent to your entry into this house. I do not consent that you're here. I have a right to silence, and I want to speak to my lawyer. Don't say anything else, maybe accept your name, but nothing else. They want you to speak. They want you to engage because they will use everything you say against you. So that's another way that they try to detain people. As you saw in Minneapolis, they broke into a man's home without a warrant. It turns out it was a U.S. citizen that they broke into. So you're seeing the violation of these constitutional protections happening right now. So, AK Poku, this is some of the ways that ICE can detain people at the home, on the street, or through the jails.
Excellent. Okay. Can you please turn on your video on TikTok? I think it's off. So if you can turn it on. Sorry for the interruptions, guys.
Let me turn my, oh, I see it. Here it goes. There you go. Does that help?
We still cannot see you on TikTok. We just see a picture of you. So there you go. Great. We can see you now on TikTok. Wonderful. Okay, great. Well,
Okay.
thank you for that.
Okay,
Thank
I'm
you
holding my camera up. You got it.
Okay, great. Okay. So, oh, you're holding your phone up?
Yep.
Do you have something to just put it on, like just mount it on or against?
Let me see if I can do it that way. Hold on.
Oh, yes, so that you are comfortable. I don't think holding it up is sustainable.
There we go. I
Okay,
just
good.
mounted it. Good.
Yes, great. Okay, that works better. Okay. Now, once someone is placed in removal proceedings, what does the early part of the immigration court process look like in terms of if they are detained? If they are detained, what happens next? If somebody just gets picked up and it's locked up.
If someone's locked up, you have to realize that even though that individual was given what we call a notice to appear, this is the charging documents that ICE is supposed to serve on the person who's been detained. You have to realize that ICE may not have filed that piece of paper, that charging document, with the court, which means the court has not, I'm sorry, the respondent or the person has not entered removal proceedings yet. However, if you have a family member or a friend who's been detained by ICE, you can file, and the lawyer who represents them can file a bond motion immediately. They don't have to wait for ICE to file the NTA with the court. So using ICE Locator, hopefully you can locate where the family member or friend is. The lawyer, most of the time, will file a motion for a bond. And within days, there will be a bond hearing by WebEx, by video conference, in front of a judge. And so immediately, under traditional practices, the individual would have a bond hearing in front of an immigration judge. We'll explain later on why that traditional practice has been disrupted. But once you're in front of the judge, you will have to prove to the judge, as the person who's detained, why you are not a flight risk and why you are not a threat to public safety. Those are the two key things. I will tell you, if you have criminal convictions in your background, you're not going to get a bond. In fact, you're probably mandatorily detainable. So that's not going to work. But if you have a clean record, no criminal history, you've been here for a long time, you own a house, you run a business, you pay taxes, you're a very good candidate for getting a bond. And the bonds can range anywhere from $1,500 up, $15,000, $10,000. The numbers are all over the place, but the minimum is $1,500. But you'll be in detention, and you'll be in front of a judge, and either through you or your lawyer, you have to present evidence of your ties to the community where you've been living. So if you've been living somewhere for 10, 15 years, and you have proof that you've paid taxes, you have a home, you have utility bills, you have proof of where you've lived, you have an employment history, maybe your employer's writing letters. Very important in proving that you're not a flight risk is that you have ties to where you live. So having a home is key, having a job is key. So that's really, really important. And your good moral character is also going to be important to show that you're not a safety risk to the public. So if you have no criminal record, that's huge. That's very positive, and that increases the chances that the judge will let you in. If you have a recent DUI, you can probably forget about getting a bond. But if the DUI was 10 years ago, it shouldn't be a huge impact negatively on you. Poku, okay, Poku, I'm going to stop there because you probably have more questions. But
Yes,
that gives people a sense of what happens.
that's right. Let me ask you, what's the difference between people who are detained? Why are some people detained in immigration jails and why are others not detained? So what makes the decision? What informs the decision, or what informs the reason behind some people being locked up while they go through their immigration court proceedings, and others are in the safety of their homes, continue to live and work, and they still have immigration courts? What's the difference between these two categories of people?
Wow, that's a real loaded question because the current situation has turned everything upside down. Historically, the people that were detained are the people that perhaps had a criminal history. They were charged or convicted on state charges. They're going to remain detained until they get a bond. They're prime candidates for detention. It also depends on what administration is in power. They're going to have different priorities. So, under President Obama and under President Biden, they wanted to go after people that had criminal convictions or charges even. And they were the priority of the folks to be arrested and detained. If someone has lived here without any criminal background, they've paid taxes, they have a family, a home, a job, under the previous priority policies of the administrations, they were not detained. They were usually let to go out on their own recognizance, and all they had to do was just come back for court. And they were not, they didn't need a bond. So the people who are under the priority list before President Trump were the ones that were detained. Under President Trump, everybody is now considered detainable. So if you entered the United States under President Trump's policy without permission, without a visa, even with parole, they're coming after them. And if they find you, they're going to detain you. And it's very difficult to get a bond under President Trump. We'll go into that in a moment. So under Trump, everybody is detainable. Everybody. Previous to President Trump, there was a priority list. But under President Trump, they will arrest anybody, even low-hanging fruit, as they call it.
That's right. Okay. Thank you for that. So, guys, we're currently on Immigration Court series with former Immigration Judge George Pappas. He's taking us through what it means to be in immigration court and things immigrants must know. This is for those who just joined us. Okay. Now, Judge Pappas, tell us, is this immigration board hearing before the judge called a redetermination? Is that the first bond hearing? Does ICE get to do anything before then, historically?
It's the first bond hearing. ICE is going to try to argue that you should not be given a bond. They're going to try to say that you are a flight risk. If there's any criminal activity, driving without a license, speeding, any traffic offenses, ICE will even use that to say that you are a risk to public safety. If you have any DUIs, driving under the influence, or driving while intoxicated, you know that ICE will focus on those past convictions to show that you are a risk to public safety. ICE will come out with your criminal history if you have one, and they will try to argue that you should not be given a bond. This is where they're coming from, which is why it's important, if you are working with a lawyer, to be completely honest with your lawyer and tell them everything about your history, even criminal history. Don't surprise your lawyer by not telling them about your background. Sometimes there may not be enough time, depending on how fast the bond hearing is scheduled, to get your criminal history. But normally most lawyers will have it before the hearing. So that's what ICE is going to try to do at your first initial bond hearing. You, as the individual, the respondent, as they call you in court, the immigrant, the burden of proof is on you to show the judge that you are not a flight risk. And you have to show, as I said earlier, that you have long ties to the community. So if you have a lease, if you own a house, if you're employed, if you have relatives in the area, if your children are in school. All of these show that you have strong ties to the area where you live, increasing the chances that you will not flee. That's very powerful, but the person detained has to get that information. Now they're detained, so their family is going to have to get this information. So what do? Don't take chances or wait to get detained to try to pull this all together. Do it now before you're detained. It's like building an insurance policy. Get those documents in place now in your home, photocopy them, digitalize them so your spouse or family members have those documents available in case you are detained. So that's the flight risk issue. Of course, public safety is the other area where the judge is going to be listening, whether you are a risk to public safety. So if you have a criminal background, you're not going to get a bond, especially if it's a serious background. You're mandatorily detainable if you have serious offenses that you've been convicted of. So the bond hearing is really a waste of time. But if you have minor traffic offenses, over the years, driving without a license, speeding, and if that's basically it, you can still go in and ask for a bond. You can even ask for a bond if your DUI, driving under the influence, was many years ago. Typically, any conviction that's more than 10 years ago should not be considered by the judge. So keep that in mind. If you have old convictions more than 10 years ago, you should be okay in terms of reducing the risk that you are a threat to public safety, assuming the last 10 years are clean. So as the individual, you have to provide documents that you are not a risk to public safety and your criminal record is prime. Of course, last but not least, you want to have letters of support from your family, from your friends, from your employer, showing that you are a person of good moral character. Without those letters, the value of your defense starts to go down. So get those letters submitted as soon as possible in English.
That's right. Let me add, what does being a flight risk mean in simple terms?
A flight risk means that there's a risk that you will not return to court when you are scheduled to appear. That's what they mean by flight risk. In order to increase the chances that you will appear at your next court date, you are given a bond. You have to pay an amount of money to the court, and the money is held hostage. It's held in a bank account. And if you do not show up at your court hearing, you will lose the money. And the more the bond, the more you have to lose. So the purpose of the bond is to ensure that you come back to your scheduled court hearing. That's what we mean by flight risk.
Thank you. Great. Judge Pappas, you mentioned that, and this is really good practice that we do for some of our clients, having family members write out letters, especially the letters from little children in their beautiful handwriting, talking about daddy or mommy. What did that do to you when you were on the bench? Did that ever impact decisions that you made in immigration court hearings?
Absolutely. I read all the letters, and most judges that I know read the letters. And yes, if I see a young child, 10 years old, 11, 12, writing a letter about their father or mother and what will happen if they're removed, I mean, obviously, it has an emotional impact on me as the reader, as the judge. It humanizes the person who is in immigration court. They're no longer just a number. They're no longer just an A number. They're a person. They're a human being. So to humanize and to personalize your family member or friend, the letters are important because the judge doesn't know who you are.
That's right.
The judge may have 20 or 30 cases in front of him on that day, if not more. You don't want to become a number. You want to become a person. And those letters of support make you a human being and a person. So they're very important, very important.
I totally agree. And on numerous occasions, I would read some of these letters. I'll look at the handwriting and my eyes just well up. So those have a very, very, they help your case, I mean, when they are relevant. Okay, so now let's move on to this. When does an immigration judge have authority to grant bond?
The judge can grant a bond as soon as the bond motion is filed in his court. And some will argue that the individual, the respondent, has to be in the judge's geographic location to have jurisdiction. But I would argue that the judge who receives the bond motion can review it under their jurisdiction at any time. One of the biggest arguments that the lawyers have had over the years with local judges in immigration courts is they'll file a bond motion, and then the judge will say, well, he's no longer in the area. He's been shipped to a different state. I can't rule on that. I totally disagree with that. I'm not going to go into the regulations. The judge has authority to rule on the bond motion, in my view, anywhere where the respondent is, as long as that motion has been filed in his courthouse. Clearly, some are going to say, well, he's no longer in my area. You'll have to refile your motion somewhere else. I'm not of that opinion.
Okay. Okay, sounds good. All right. Now, who has the burden of, I think you answered this question, the burden of proof in bond hearing is obviously on the respondent or on the immigrant. I think you answered that. You're the one that, can you just touch briefly on it?
Yes, the respondent has the burden of proof to prove that they're not a flight risk and not a threat to public safety. That's your burden. That's your responsibility, which is why it's important to gather all these documents proving that you're not a flight risk and not a threat to public safety, hopefully before you are detained. So do your homework now, and just in case, have those documents ready, because the burden is on you.
That's right. Okay. Now let's talk about this. Again, you touched on it, but what types of evidence are most persuasive in a bond hearing?
Criminal history. Let's start right there. One of the most important documents for value and weight is your criminal history. So the Department of Homeland Security is definitely going to have an FBI and fingerprint check on you, both nationally and maybe internationally through Interpol. So you as a person want to make sure with your lawyer that you get your criminal history up to date as soon as possible, so you can see what the judge sees. You don't want to be surprised in the hearing about what your criminal history is. The last thing you want to do is surprise your lawyer. Make sure that has all that information. So your criminal history is going to be the most important documents they're looking at. Obviously, if you have convictions, you're not going to get a bond. You're mandatorily detainable. However, there's other offenses that don't make you mandatorily detainable. There are some offenses which are so serious, they're called aggravated felonies. They will permanently lead to your deportation and permanent deportation from the United States. And you're not going to see a judge if you have an aggravated felony. You're going to go straight into expedited removal and shipped out. So if you have a serious felony, you're not going to be getting a bond. You're not going to see a judge. You're going to be deported, and you're permanently legally barred from the United States. But outside of the criminal history, the second most important thing really is showing documents that you are stable where you live, that you have connections, you have ties to your community. Like I said earlier, you have letters from your employer showing that you've been employed in a certain position for so many years. Colleagues who work with you, they can write letters to show that you're a great employee. Of course, your family and friends are going to write letters about their relationship to you. All of this shows that you have ties to the community and you have good moral character. So those letters of support from your employer, your family, and friends are critical. So you got criminal history. Letters of support are also critical. The other thing which is really important is photographs of you and your family. If you want to humanize yourself, get photographs into your file. Show yourself with your family in church, or maybe at an event, or at a holiday, or at a gathering with friends and family. I cannot tell you, those pictures are worth 1,000 words. So photographs, letters of support, of course, your criminal history, hopefully be clean and not too serious. And you may have witnesses that want to testify in court or online about you in front of the judge. So be prepared to call up certain people that can speak to show why you should be given a bond. And last but not least, your financial stability is also considered by the judge when they set a bond. Can you pay the bond? Do you have a sponsor that can help support you? All of these things are important. So your financial ability to pay the bond also is important. So all of those documents are really critical at the bond hearing. And, the hearing may take place in between 5 and 15 minutes. It's not going to last long. So you have to have all these documents ready to go. And two, the judge has already read the file. So if you filed all these documents, the judge has read them. And this gives you an opportunity during the hearing to explain what the documents mean, because the judge has them. So before the hearing, the judge already has a picture of who you are. They think about where you're going. So what's important in the hearing is how you testify, and if you have witnesses, how they testify, which could tip the balance. That's why having witnesses is really critical.
Okay, thank you. And let me just add that examples of aggravated felony that Judge Pappas mentioned are murder, rape, sexual abuse of a minor, those type of serious offenses. There's obviously lots of other offenses also that are aggravated felonies. And I think you mentioned another thing, very important, pictures. Those pictures are really, they can really help a case in various types of immigration court hearings. For example, you are a dad and you have minor children, and perhaps one of the child has special needs or has some type of disability where they are using medical assisted devices. Dad is seen in the hospital, being present, working multiple jobs. And as Judge Papa said, these things are things that can tip the balance in your favor, because the judges are human beings. And so presenting your story, make sure that your story aligns with the law, but also elicits the emotions that's supposed to elicit. Very important. Okay.
Very important.
Now let's move on. You mentioned the bond amount, that there are varying bond amounts, lowest $1,500 for you to be able to guarantee that somebody will come back. And then it can go up to about $15,000. What determines these bond amounts during the time you're an immigration judge? What were some of the things you would consider?
This is a subjective area that each judge has to incorporate into their decision. There's no black and white paradigm, formula that says, if you do X and you'll get Y, if you do Y, you'll get W. But what the judges are going to consider certainly is, first they'll go to flight risk. And if they don't see any serious criminal history, that will increase the chances that your bond will not be as high. If your history did include some DUIs a couple of years ago, the judge may increase the bond amount because there is a risk perhaps to public safety. Also, your ability to pay the bond will also be considered. If you don't have any evidence of employment or assets, or maybe even a sponsor, the judge may be reluctant to give you a reasonable bond. You have to have enough money to pay for the bond. So you have to prove that you can pay for the bond. So your ability to pay is going to be key. If your ability to pay is very strong, clearly a reasonable bond amount will not be unreasonable from the judge. $8,000, $7,000, $5,000 is pretty much normal. So clearly the judge is going to look at your ability to pay. Obviously, if you're a sole provider of a family, one parent, and everybody's depending upon you, the judge may not hit you with a very high bond because your financial ability affects so many other people. So that's why it's important to humanize your background, to show the kinds of responsibilities you as an individual have and who's dependent upon you. You may have a sick parent. Maybe they had a double lung transplant. They're dependent upon you. The judge may not give you a high bond because of your responsibilities. So clearly, your family responsibilities, your ability to pay, and a pretty clean criminal record is going to help get you a lower bond. In this environment, if you have anything in your background which says there may be a risk to public safety, maybe driving without a license, driving and speeding, and you have many of them, maybe 5, 6, 7 of them, you may get a high bond of maybe $10,000, $15,000. Also, judges are under pressure today to not give bonds, and where they do, for political reasons, they may order a higher bond because the judge is fearful that he will appear too lenient. So now the individual's getting penalized because of the pressure that's being put on by the administration on judges. So where normally they would grant maybe a bond for 5 or 6, they're now granting a bond for 10 to 15 or more. So those are events and conditions beyond the control of the respondent, but you have to be aware of the political environment that we are in today. And any bond that's given today is going to be probably higher than it was a year ago. So those are some of the elements of what a judge will use to review a bond for an individual.
Okay, great. Thank you for that. All right. Can the immigration court consider alternatives to detention instead of setting a high bond?
Yes. Instead of a high bond or a bond or any money bond, the court can order that you will be released on your own recognizance, which means released on your own. They may order that you check in with ICE, Immigration Customs Enforcement, once a month. They may, basically what they're doing is putting restrictions on your freedom, not in terms of money, but in terms of reporting to ICE. So that's another way that you can be released without paying money.
Okay. Now, if bond is denied for an immigrant, what are the options for a detained immigrant? That means they get to remain in immigration detention. What options do they have?
They can appeal the bond decision to the Board of Immigration of Appeals and ask the Board of Immigration to review the decision of the immigration judge. And if the board agrees with the individual, the respondent, they will order the individual out, or as they say, remand it back to the immigration judge to take further testimony. So they can appeal the decision right away to the Board of Immigration of Appeals. That's another way of challenging the bond.
Okay. Now, why has EOIR, the Executive Office of Immigration Review, that's a federal agency that oversees immigration courts around the United States, why has the EOIR instructed immigration judges not to hear bonds?
This is a, go ahead.
No, I'm sorry. Even in light of the U.S. federal court certified class actions, the rulings that state EOIR's policies are unlawful.
This is the current problem that we are facing nationally with the EOIR policy. And as evidence of this, EOIR, just a few days ago, maybe 10 days ago, 12 days ago, instructed all immigration judges that they do not have jurisdiction to hear a bond for people that have entered the United States without permission. EOIR's policy is these people are now in what we call expedited removal. We'll go into that later on. They're mandatorily detainable, and they have no right to ask for a bond. So if they file a bond motion, the judge is going to say, I don't have jurisdiction, because that's what EOIR tells me to do. Here's the problem with this policy. And what's even more problematic is that this policy was issued after the U.S. federal court in California, the U.S. District Court, ruled that EOIR's policy, the Department of Homeland Security's policy, also is unlawful. They actually said that a case that was issued by the Board of Immigration of Appeals, this is the board that above the immigration courts, ruled in a case called Hurtado back in September. The board came out and said, yes, in fact, if you came into the United States without permission, entered without inspection, no matter how long you've lived here, you are mandatorily detainable, and you don't have a right to ask for a bond in immigration court. Wow. Well, the courts in California, the federal courts, which are over the BIA, over the Board of Immigration, ruled that that's unlawful. And they did say, we vacate Hurtado. Another federal court in Massachusetts did the same thing and said certain people in a class who are in the United States without permission, who've lived here for more than 2 years, are part of a class, and they are entitled to ask for a bond. So you have federal judges, federal courts, class action suits, which are nationwide, that have ruled that what the Department of Homeland Security is doing is unlawfully detaining people and telling them they don't have a right to a bond. So now what happens? Instead of lawyers wasting their time going to immigration court, knowing that immigration judges are going to say, I don't have jurisdiction to rule on a bond hearing, lawyers are now going to federal court and filing what's called habeas corpus petitions. These habeas petitions go in front of a federal judge, and then the judge rules on whether that person is being lawfully detained. And if the federal judge says, no, they're not being lawfully detained, they will either order the release of the individual from detention, or within days, they will order the immigration judge to hold a bond hearing. And I can tell you at least half the bond hearings today are because of these habeas petitions being thrown back to the immigration judge. And there they do have a bond hearing because the federal courts told them to do so. You would think that the Executive Office of Immigration Review would follow these court rulings which are binding, and obey the law. So what we have here, ladies and gentlemen, is the agency, the Executive Office of Immigration Review, which is a department within the Department of Justice, which falls under the executive branch of the United States government. And we know who's head of the executive, President Trump. That agency is defying the law. So we have a lawless Department of Justice telling judges to disobey the law. So you have judges sitting on the bench today, knowing that they're disobeying the law, but they're being told by their supervisors, don't hear a bond hearing. So we are stuck in this Alice in Wonderland environment today, where courts, immigration courts, are defying the rulings of federal courts to hear bond requests. This will eventually go to the Supreme Court, where it's going to be finally ruled upon. But as we speak today, individuals who have rights, due process rights under the Fifth Amendment, are having those rights violated by the immigration judges and their supervisors. This is the sad reality of where we are today.
Thank
There
you.
go. Yep.
Okay.
That was a lot. That was a lot to explain. That was tough.
Well, you did a good job explaining that. Thank you so much. Judge Pappas, you mentioned something also earlier about the fact that, and it's a reality that many immigrants are facing, they tend to be reactive rather than proactive with regards to their immigration status. And so they'll hear you saying everything, just, attorneys are telling people, do this, do that. But somehow everybody thinks that they're special. Well, I'm never going to get detained, and so I don't have to bother. But one reality is that when you are detained, it becomes very difficult for your family members to try to put together documents for you and, try to pull things together for you. So tell us about, some of the documents people can proactively prepare just in case the unfortunate happens.
Here is your pre-detention bug-out bag, as we want to describe it. This is your security blanket. Maybe I'll use that term. These are the documents you should have ready to go. 1, your birth certificate. If it's in a foreign language, have it translated. 2, if you're married, have a copy of your marriage certificate. If it's a foreign marriage certificate, have it translated into English. 3, if you have children in the family, you want their birth certificates in that file. Hopefully they'll be English birth certificates. So those 3 documents right away are critical. Next, if you own a home, you want a copy of your deed. 3, if you're employed, have proof of your employment, employer letter, ID card. You want to have that. 4, if your children are in school, have proof that they're in school. Their educational report cards will be really key. 5, if there are any medical conditions with any family members, you want proof of their medical conditions. You may have a letter from your doctor. Put that in the file so the doctor can explain any special needs that your family members have. Those are very, very important. Beyond those core documents, you then want maybe proof of taxes, which is very important to a judge. They want to see that you pay taxes. The longer you've been here, the longer you should show that you've paid taxes. If you've been here for 25 years and you haven't paid taxes, you just reduce your chances of getting a bond. Pay your taxes. You don't need a social security number. Get an ITN number. Talk to your accountant and get one and start paying taxes. So outside of those core documents, you may want to have photographs, obviously, of the family, pictures of any family members who have special needs. You want to visualize this, have this in your packet. And of course, any letters that you can have from the community, from your church, from your friends or employer, showing how good you are as an employer. It could be a general letter of recommendation. And then you put this all in one package, photocopy it, and store it away in case of an emergency. Even better, digitalize it so it can be emailed to, let's say, a lawyer, no matter where they are, immediately. This is being proactive, not reactive. If you do that, you're going to increase the chances that you're going to get your bond a lot sooner. Because if you don't have those documents, you're going to sit in jail. You're going to sit in detention while your family is scrambling trying to find the documents. and you don't want to be sitting in detention. The conditions are not good. The food is horrible. If you have special medical needs, good luck with that in detention. So this will save you time because you'll have the documents ready. That is being proactive.
Yes, great. Thank you. And I tell people immigration detention is a very horrible place to be, and especially around this time of the year where conditions are so frigid in many parts of the US. It's just so cold. Many of these places don't even have proper beds for you to sleep on. Very cold, very terrible place to be. So you want to get out as fast as possible. One of the things that I'll add to what George Pappas, you guys remember that this is not legal advice. It's for education purposes. You need legal advice. Make sure you contact an effective, experienced immigration attorney that can assist you. There's a lot of people running around that don't have law licenses, don't have the experience, and will mess you up. We see it all the time. So make sure you're going to somebody that you trust with your future. Okay. Now let me talk about the fact that having George Pappas having a signed G28 is also very important. In addition to some of these, identity documents, proof to your community, having a G28 means that you have an attorney, you have the phone number of the attorney, you've retained the attorney, and the attorney is your legal representative or can speak on your behalf. Because what happens is that, as we mentioned, if you have a digital version of your packet, pre-detention packet or just in case packet, you scan it to yourself and to your wife or to your whichever trusted family member or friend. If your friend sees that packet and you happen to be detained, they'll see the phone number of the lawyer that you've worked on your bond packet with. And I will encourage you to do that, just in case you're detained. Work with an attorney. They will guide you on exactly what you need to, put together. They'll work with you on that. And another thing, this is also a call for immigrants to be better human beings, honestly, because if you are somebody that's beating your wife blue, black every day, when you get detained, she's going to say hallelujah. She's not going to fight to get you released, and even being kind to your family in times like this, because you are able to document it. And then when it comes to it, a judge can see your life through pictures, through stories, and through a life you've been living. And then it always speaks for you. Being a good member in your society, being a good member at work, at your church, volunteering, and it's just really a charge also to immigrants to do better wherever they find themselves. Judge Pappas, is there any other thing you want to talk about? And then we'll pick a couple of questions. Please drop your questions and we'll be answering them.
In detention, unfortunately, you're going to be wearing an orange suit. So you're not going to be able to dress properly, nicely. And that's a disadvantage to you. However, you're still going to get in front of a screen and you're going to be speaking to the judge. Try to be somewhat respectful. Good morning, Your Honor. I appreciate the fact that you're listening to my case. Try to humanize the relationship between you and the judge. Don't argue with the judge, but do your homework before you speak to the judge. Say to yourself, why am I not a flight risk? Why am I not a threat to public safety? Introduce your family to the judge when you are speaking to them. Humanize yourself and try to look straight at the judge on the screen and just try to look professional. I can tell you how many detainees, people who are in immigration court, they come up to the chair and, they're sitting with their hands up like here. They got like a baseball cap behind them. They don't care. It shows they don't really care. And you want to be professional. You don't want to be like them. And the judge is watching your demeanor, how you appear, how you speak. Take advantage of that opportunity to show that you are better than everybody else, that you're a good citizen or resident, that you contribute, and speak with conviction. You're advocating for yourself. Of course, you'll have a lawyer there perhaps on the screen. Remember, your lawyer may not be next to you. So do your job as best as you can to express yourself with integrity and with honesty to the judge. This is your 5-minute chance to explain to the judge who you are. You're on stage, perform. A lot depends on it. So I'll just leave you with that.
That's right. Yeah. Yeah. Your ability to tell your story is really important. And if you cannot tell your story, you hire somebody that can tell your story for you or help you tell your story within the context of the law. Because at the core of it, it's really storytelling to the judge. They're hearing multiple stories. And so you want your story to stand out, be honest, and be viewed in the best possible light to get you the best results. So it's your chance. Obviously, you really, yes, you have to make sure that you comport yourself and you speak properly with intentionality. And yeah, all these things will affect the outcome of your case. Okay, let me pick one question here. Let's start with this one. Ebenezer Ninaku says, why this is from Facebook. Can you ask him why, if your case denied, immediately put removal notice on you? Let me answer that, and then I can also let Judge Pappas chip in. You guys, we've been saying this from last year, February 28th, 2025. USCIS, which is the federal agency that adjudicates affirmative immigration applications, your work permit, your green card, your citizenship application. They released a memo, a USCIS NTA issuance memo, and the memo said that the new policy is that immediately your case is denied and you are found to be unlawfully present in the United States, meaning you're here without a visa, without permission, I should say, because some people could be here, their visas are expired, but they are in a period of, they are in valid status, is what I should say. They are in lawful non-immigrant status, meaning they have an I-94 that's still valid. If you do not have lawful presence and your case is denied, then they are going to put you in immigration court or immigration proceedings, because you are signaling to them that, well, here I am, I don't have presence, and now your case has been denied. So you're getting sent straight to immigration court, because that's the policy, that's the new Trump policy. So we're seeing it more and more. But Judge Pappas, I'll allow you to also chip in or chime in on that.
Well, if you're denied by USCIS, in some cases you can appeal directly to the Board of Immigration of Appeals, depending upon your application. If you are trying to remove conditions from your legal permanent residency or from your green card, let's say you got a green card and you were married for less than 2 years, you have a conditional green card and you have to remove those conditions within 2 years. And let's say, for whatever reason, USCIS denies your ability to remove your conditions, they're now going to refer you to immigration court. If you're applying for asylum, affirmative asylum means you're applying to USCIS for asylum and it's denied, they're going to refer you to immigration court. So in many instances, a denial from USCIS is going to refer you to immigration court. When that happens, you have notice of it right away. This is when you have to prepare your burden of proof. You have to contact your lawyer, get your evidence together, use that time to prepare for your first court date. Eventually, you will get a notice to appear from the immigration court. And that's when you have to appear in court for the first time. So from USCIS to immigration court happens all the time. You have denials all the time, and you're referred to immigration court. In some cases, you're not referred, as I mentioned earlier. If you are appealing, let's say, adjustment of status, you're looking for your green card, that is not an appealable application. You can file a motion to reopen with the USCIS. You can file a motion to reconsider. Those are other avenues that look like appeals, but they bring your case back to USCIS. And if you don't prevail on that, you are out of status. And you will be getting a letter saying that you have to vacate the United States by a certain time, or you can reapply again if you have new evidence. But the role of the courts comes after the denial from USCIS. There's usually a gap in time. Use that time to prepare your case. Use that time to find a lawyer if you don't have one. There you go.
That's right. Yeah. And it's really important that people know how to check their status. You go to the EUIR case status, you put in your A number, and you should be able to pull up whether you have an immigration court hearing coming up, or you've been deported, you've been ordered deported by a judge previously, or whatever your status is as an immigrant in terms of immigration court. Okay, we have a question here, Benji Asari on YouTube. He says, if my visa that I used to enter the USA gets revoked, I applied to adjust my status through my US citizen child before my visa was revoked. I am currently in detention. Can I get a bond bail? And again, let's keep it general. We are not going to give specific legal advice because we're not allowed to do that on video. You know, we'll have to, these are things that are usually, they have to be reviewed to make sure that we're giving you good, but general information, Judge Pappas.
Well, the individual used the word revoked. That's different from coming in with a visa, let's say a F1 for a student visa or a tourist visa, B1, B2 for work, and you overstayed your visa. That's one type of scenario where you're in unlawful status because you've stayed beyond your visa. Getting a visa revoked means the State Department took express action to take that visa away from you. That's a little more serious. But you're arrested, you're put in detention. Yes, of course you have the right, the constitutional right, to ask for a bond. Today, that's going to most likely be through federal court. So if you don't have a criminal background, you're not mandatorily detainable. More likely than not, you're going to have to go to federal court with your lawyer, file a habeas petition to force the immigration court to hear your bond request. So you are still eligible to hear a bond so long as you don't have a criminal background.
Yes, thank you. I suspect that Benji Asari is actually asking about a Ghanaian Minister of Finance Minister, Ken Ofori-Atta. It sounds like this is his smart way of asking about that case. I could be wrong, but that's my suspicion. We have a Ghanaian foreign minister who is actually currently in the United States, and I believe he's supposed to face some court hearings in Ghana for some corruption charges, and he is in detention. So I suspect that this question may be coming from that angle. But Ben, please confirm in the comments and let me know if I'm spot on or not. Okay, now let's see. Thank you, Judge Pappas. Thank you for that. Let's see if we have a lot of other questions on Kwesi in Tiamoa. Let me see if there's something here on bonds, because we have a lot of other topics. Well, let me see if Judge Pappas, you want to answer this one. Kwesi in Tiamoa says, my form 601 was approved and now have the green card. Will I have any problem filing for citizenship?
Didn't have any problem because the 601 is a hardship waiver. It shows that you may have lied upon entry into the United States. You may have used false documents. There are other categories that this waiver forgives you for. So if you got approval from USCIS for this waiver, you've already done the hard work. They would have not granted you the green card without that waiver. So there's no reason why you just can't, when you're eligible, apply for citizenship. So go right ahead, go straight for citizenship. You're in good shape. The 601 waiver was already reviewed, approved, and you got the green card because of the waiver. The deck is clear, the coast is clear, run to citizenship.
Okay. Yeah, and just to add to that, you know, the 601 waiver, for example, if you have some type of inadmissibility, like you, as he said, maybe you committed some type of fraud, immigration fraud, you lied about. Some people, for example, they go to the US Embassy and they are going to apply for a B visa. You know, a B visa is a temporary visa. And for many countries or the consular offices, if you are married in your home country, then they see it as a good sign or a positive sign. And so they would usually issue you a visa because you are married and perhaps you have 3 children. And so some people will go, or they'll be told by agents, visa agents, okay, say that you are married, say you have 2 children. Meanwhile, the person is not married, doesn't have any children. So they'll say they are married, come to the US, and then they apply for a green card, and then the case gets denied. And USCIS says, well, you said you were married, you didn't include a divorce decree. At your interview, you admitted that you've actually never been married. This is your first marriage. And so you need to file a 601 fraud waiver. Remember that the waiver is you asking the US government for forgiveness. And once it's approved, that's right, you have been granted forgiveness. So your sins have been forgiven, just go and sin no more. But citizenship, yes, absolutely. You just need to make sure you are clear before you apply. It's become so dangerous because sometimes I'll tell you guys, green cards are issued in error by USCIS. And if you apply for citizenship and they catch the error, we've seen a lot of those kind of cases. They are likely going to send you to immigration court because you should not have received your green card. So, at each stage, yes, sure.
Can I give an example of where someone
Yes.
had a problem with their citizenship after they got their green card? The lottery visas are a place where you see people making their life difficult. There's a question on the lottery visa application. Do you have children? And the applicant says, no. The question is simple. Do you have children? They say no. They get picked in the lottery. They come to the United States. They get a green card. Now they're going to sponsor their family to come in. They come in. They get their green card. Now that person wants to become a U.S. citizen. And it's discovered at the naturalization interview that she has a whole family here of children. And they'll go back to the form she filled out. It's called DS-260. And they'll say to the applicant, you said you had no children, but obviously you have a whole family here of children. Why did you not answer the question accurately? They will consider that a material omission, and you will be denied your citizenship at the interview for your application. So make sure that you always tell the truth, because if you lie, it will come out somewhere along the line. The person many times will say no if they have children because they think they'll increase their chances of being selected. Big mistake. Big mistake. Don't do it.
Yes, the diversity visa lottery, yeah, that's the rumor on the street that if you don't have children, you get picked. And so people who have children constantly, well, many of them will lie and say they don't have children. And then they'll come and then they want to file for the children, or they are, there's some way, somehow the children come up, because when they're doing the naturalization, they now mention the children, and then it becomes a problem. And now let me tell you guys, according to the February 28th, 2025 USCIS NTA memo, if you apply for naturalization and you were not somebody who should have received your green card, your naturalization application will not only be denied, but you will also be placed in removal proceedings for that green card, because now you don't have a green card and so you are left hanging. Let me ask you this question. I think we can take a couple more questions and we wrap up. Doe Victor on Facebook says, please ask him if someone's case is dismissed in immigration court without hearing and the person asks to self-deport, or they will send him to third-party country, what will the person do? I don't know if you understand.
I think I understand. We have to be careful here and not give legal advice.
That's right.
If you are ordered, if you ask for voluntary departure and the judge gives it to you, you have to leave. The judge will give you an advice that if you don't leave, you'll be sanctioned to a monetary penalty and you'll be barred from coming into the United States legally for 10 years. So if you ask for voluntary departure, you'll be given a certain time, maybe 120 days maximum or 90 days, where you have to leave the United States. It gives you time to make your own arrangements to leave. You may have to present your passport to ICE and tickets to show that you're leaving. So if you're given voluntary departure, obviously you're asking for it. Or if the judge offers it and you take it, you take it. The issue about third countries is totally different. As the government has been aggressively seeking to do, they have formed these agreements with about over 20 countries now around the world. And the Department of Homeland Security is filing what's called pre-termission motions, basically telling the judge they can ask for asylum in a different country, Your Honor. They don't have to be here. We ask that they be removed to a different country. That's pretty dangerous, because if you're asking for asylum and you come from, say, I don't know, Brazil, and the government says, well, we don't want you to hear that case, Honor. The person from Brazil can go to South Sudan or Uganda. They can go there and you don't have to hear the case. The judges are granting these motions and ordering that these people be removed to third countries. You have to think very carefully about what kind of relief you're asking at the court. If you get voluntary departure, you maintain control of where you go. So if you want to voluntarily deport back to your country, no one's going to bother you. They'll send you there. especially if it's voluntary departure, because you're making your own arrangements. When you're ordered to go to a third country, you don't have control. You're in removal proceedings now, and the judge has to make a decision where you should go, either back to your country or somewhere else. AK Poku, that's the best way I can answer that question.
Thank you. Let me just ask you this, Judge Pappas. I know people have been asking, okay, if I'm deported to a third country, do I get there am I detained in the country, or I'm a free individual and I can walk around, I can find a job, I can live? I know that Tom Homan was asked this last year, and he was like, he has no idea. Even Tom Homan doesn't know. But what do you think? What do you think about that?
Well, it starts with the agreement that's signed between the United States and the country. What's in the agreement? If the asylee is transferred to that country, are they going to be detained? Are they going to be allowed to ask for asylum but not be detained? So you start with the agreement, and the burden of proof really is on the Department of Homeland Security to show the court what's in that agreement, because the individual is still entitled to due process rights. You don't want to send them to a country where they're going to be persecuted. So that's very important. You want to make sure that they're going to a country where they're not going to send them back to the country they're trying to get away from. So the agreement spells that out. Of course, it's all driven by the agreement and the laws of that country. The big fear of being deported to a third country is that you will be detained and they may reship you to the country that you don't want to go back to. This is the big fear. So yes, the burden is on the government, and your lawyer should be asking for it, or you should be asking for it. What country are you sending me to? What does the agreement say? What are my rights there? Do I really have rights there to ask for asylum? And will I be prevented from returning to the country that I fear? Will I be detained or will I not be detained? I have the right to know that. Yes. Because as the individual in deportation proceedings, if you can show the judge that you fear returning to this country, even though you've never lived there, let's say it's Honduras, but from the agreement, you can see that you're going to be detained, and you see that perhaps other people have been reshipped to another country. You fear going to that country. They're going to have to find another place that's safe for you. So the agreement is really key. And many times the department is getting away with not showing the agreement to the judge because the attorney is not doing the job, or the individual is not knowledge enough to ask for it. You need to demand that and see what the agreement says to ensure safe passage or safe removal. Thank you.
Yeah. Yes, this is really scary, and it really causes a lot of nightmare for a lot of immigrants, because just imagine being transported to a country you've never been, and perhaps you don't even speak the language, and you could perhaps be detained in that country with a bunch of other strangers, and it's like, oh my God, this is a living nightmare, honestly. Okay. Thank you for that. Let's take our final questions. I see many of you have a lot of questions. We will not be able to answer everybody's question. Guys, if you have not already liked our pages across social media, please do so. AK Poku, Attorney George Pappas. George Pappas is also on social media, so follow him also across social media. And this is the first episode of our Immigration Court series. He'll be coming once a month throughout this year. We're going to be demystifying immigration court. You guys, he sat on the bench and made decisions about who gets deported from the United States, who gets a green card. President Trump, you guys know, several months ago, he let go a lot of immigration judges. He's one of them. He's talking, he's discussing what goes on in immigration courts, the most intimidating place for immigrants, especially in Trump's America. So please make sure that you're following us across social media and you stay tuned, because you're not going to hear this information anywhere. Okay. All right. Let's take our final question. What can someone do if he has no scheduled court dates due to backlog? This is from Felix on Facebook. Faris Felix.
Yep, this happens a lot, and many attorneys that represent immigrants will file what's called a motion to set hearing. They're asking the court, schedule a hearing. And so you file a request or a motion with the court, and you're telling the judge, I'm waiting, schedule a hearing. Obviously, many courts have this long backlog, but I can tell you every week, judges get motions to continue. And when those motions are granted, it opens up the schedule a little bit. So there are opportunities for a judge while they're sitting in their office to say, all right, I'm going to schedule this person on this date that just opened up. Because when you file a motion to schedule a hearing, you're telling the judge, we're ready to go. We have our documents, our application's been filed, we're waiting. So that's one way to perhaps get your hearing scheduled sooner. You have nothing to lose by asking the judge, schedule a hearing as soon as possible. Put it on the record. You have nothing to lose by coming back 60 days later and asking for it again, because the schedule changes almost every day because spots open up. It's constantly fluid, and you may get lucky and the judge will say, okay, I'm going to put that person here, send them a notice of hearing, they're done. It's that simple. If you do nothing, then you're going to have to wait. So if you want to wait, that's what you want to do, then do nothing. But if you want to be heard, be proactive. Talk to your lawyer. File those motions, Mr. Lawyer or Mrs. Lawyer. Ask the judge to set a hearing. Tell the judge we're ready to go.
Sounds good. Sounds great. Judge Pappas, did you want to wrap up? You can tell people how to reach you. Any other final words, and then we can.
Yeah, thank you, AK Poku. I'm on social media. I'm on TikTok now. I also have a website. Just go to Pappas Legal PLLC. Pappas Legal PLLC. Of course, if there's an emergency and someone's been detained, just call my 24-hour number, 828-903-8987. There you go.
Okay, sounds good. Pappas Legal. All right, guys. Well, thank you all so much. You need one-on-one legal advice. We're here to serve you. Please remember, immigration courts, you don't want to just give your deportation case to people who don't have an idea what they're doing or who don't have time to work on your case. So make sure you contact AK Poku Law. You can contact Pappas Legal. His number is right here. And we'll all be happy to assist you. Thank you all for joining today's session. As you guys know, we're live every Friday, 1 p.m. EST. We talk about immigration updates. And this year, once a month, we're going to be doing the Immigration Court series with Dr. George Pappas, a former U.S. immigration judge. And thank you so much, Judge Pappas, for being here today. We appreciate all the insights, and hopefully we'll see you next month. Thank you.
Pleasure. Thank you.
Thank you, everyone. Thank you for joining. Don't forget to hit that follow button. I'll see you all soon. Take care. Great weekend. Bye.
Bye-bye.
Thank you, TikTok.
There we go. Take care.